That's gotta be one that give a shot, you know? I can get you five. And the truth is, if you really want to go, I can definitely to take everything I can listen to. It's no problem. Oh, yeah. Or leave me alone. Yeah, me cheap. How do you want to look at that? You know? Yeah, also. I was like, I'm going to make a single call. I was honorable. You just come to play. I'll give you a reference. No one will do it. Take the play, but don't worry about it. I won't get you. Oh, yeah. I mean, I need to stand on because I stand them all off fast.
Hey, where's the boys over there? Hey, what's going on? How are you?
There was. All right.
Will we get next week? Okay. Just went a lot bigger. Okay. Cool.
Hi.
Yeah.
I don't want to sit down till I have to sit down. Your book what?
Huh? Really? I'm not calling
Does it have a sticky on it?
Used to. Ashton, how the heck did we...
Put it for a button.
Oh, goodness. Yeah.
That's on everything. That draft that I had approved by city attorney, that little stamp drop that I had approved by city attorney, that's on any ordinance that hasn't been approved by the council yet, that hasn't like made it onto the agenda or been a part of the official backup. And this is definitely a draft. Work in progress. Did you have a chance to look at the most recent draft?
I saw.
I just want to show
So that's what you got.
130.
Put those in your car.
30 days, so 137 plus the bar.
Right.
And also you check here at the front.
That's 54. That's your top paragraph. City grass. She just emailed today, Fran. She just emailed me today that she'll have it. That she'll have. The Lord County Park is pretty nice.
But I mean, so we've got.
But she's done all. She's done all.
This is the other new practice for life.
The less famous.
Janice.
No, but there are, Definition. I'm just
Yeah, it's good.
Did you get an update out on the live stream?
Because it's not the responsibility of the span here. They don't No, I'm not a breeder.
She's the one that came over that new language to find
They still do that. A lot of leaders hold themselves to that. I know a lot of leaders who they didn't do whatever it's wrong. They don't want to put their bloodline out to anybody, regardless of their love or their hate. They don't want their bloodline to work. We don't want to go. It go 20 years ago. Thank you, but somebody's going to because I they're the only ones that are with the club store, the brushes, automatic litter boxes, doesn't qualify as a home.
your
The way the rules of the boxes. Most of them produce themselves there's not money in it's not a money. What a that's what you want to do. People who are responsible and then to like that and also there's the peer pressure, but you have to hold yourself to that same standard. Oh yeah, those are the ones who kind of the ones who regulations. You gotta, I gotta, you know. That's you're not gonna let it be also you have
Okay, everybody, we're going to go ahead and get started. We're about 8-9 minutes beyond the start time, but I think the trickle off the elevators is like a stream slow to a trickle. So everybody else that walks in will just catch up as best they can. I'll point out, I think most everybody has noticed the sign-in sheets in the back. If you haven't had the opportunity to just jot down your name and tell us a little bit about who you are, please do so before you leave the meeting. So I'm Chris Newport. I'm with the Administration and Regulatory Affairs Department. BARC is a division of ARA. I know a lot of you in the room know this. Everybody's pretty, most of you are familiar. But just a little bit of backstory. BARC has had has an interesting history to it. My department took over responsibility for BARC from the health department in January of 2010, and for the 3.5 previous years from today back to when we took it over, it's been a pretty intensive restructuring exercise. The organization was in pretty rough shape and we got involved. And what we're talking about today is kind of we started keeping a running list whenever we took over BARC, and the folks that were at BARC had this list going, but we had to focus our resources on making sure that we had a new, stable, and responsible and compassionate organization. So that's been achieved. There's still a lot that needs to be done at BARC and a lot that we want to do, but we've got a stable base under us. We're on kind of sound ground, so we're able to turn our attention over to a list of ordinance revisions that we wanted to do for some time. So I'll just introduce to you all. I know a lot of you are familiar, again, you know us and we know you, but just so everybody's on the same page here. We've got Chris Glasser, who's one of our animal control managers. Jared Mears, who is our other animal control manager. They do great work running the animal control operation for us at BARC, particularly given the really stark resource constraints that they have. And they can field about 6 or 7 guys on a good day to respond to more than 400 requests for service that we get for them to respond to situations across the city of Houston. Charles Jackson is the shelter operations manager. He manages all the animal husbandry and essentially makes BARC in terms of facility and moving animals and making sure that they're cared for. Greg Damianoff is here. He's the director of BARC. Ashton Revette works for me, as does Alexander Hahn. And Tina Paz is here. She's the director of our department, Administration and Regulatory Affairs. James Koski is here from the mayor's office. He's a deputy chief of staff for the mayor. And then we're also joined by Jonathan Newport, who's a representative of Councilmember Jack Christie. Edna Campos, they're from Councilmember Melissa Noriega's office. Melissa Arredondo from Councilmember Stephen Costello's office. Have I missed anyone? I don't think I have. And all the faces that I recognize and that I don't, thank you, welcome for coming. This is the second, well really the third stakeholder meeting that we've had on proposed revisions to Chapter 6. We had intended to live stream this as we did for the first event, but we're having some technical difficulties. So for the people that you know that couldn't be here, if they were expecting to be able to tell them that, if you can just let them know, put an announcement over Twitter and Facebook already, but let them know that we had some technical difficulties. So it doesn't look like we're going to be able to make that happen, but we're still video recording, and we're going to get it up on YouTube maybe. Okay, so with that out of the way, I've covered background, we've covered introductions. So what we're, just for the purposes of this meeting, we're going to ask that if anyone wants to talk about park operations, what we're doing with our Healthy Pets, Healthy Streets initiative, how our adoption's going, how our live release program looks, what our outreach function looks like, how we work with rescue and foster organizations in the city, I'm going to ask everyone to hold that until after 8:30, because what we want to do right now is focus on all of our attention on getting the questions answered that you all might have about the proposed revisions that we have to Chapter 6. Chapter 6 captures, for all intents and purposes, all the animal regulations that apply within the city of Houston. So Alex, just go ahead. We've covered this already. Go ahead. So I've run through that. So this is a pretty comprehensive rewrite. You'll notice, let me back up a little bit and say that we have on our website, which is houstonbarc.com, we have a version of the draft ordinance available on the website. We have essentially everything that's on that back table, the PowerPoint that we're looking at right now, a spreadsheet that has an item number, the section that's being revised, why it's being revised, and some additional color available for you to download. And then we've also got a document that kind of articulates some of the feedback that we received from the first meeting and how we responded to that and how we revised the draft. So we're going to be making updates and announcing updates to that page, primarily through our Facebook page. So if you all could focus in on the Facebook page, that allows us to get, it minimizes the channels that if we need to get information out, we know that's one place that we can get it out to, and everybody likes all of it. So you'll see in the draft a number of different revisions. One of them is as basic as revising how park is defined. It was defined as the Bureau of Animal Regulation and Care. Bureau is a specific organizational descriptor that's utilized by the health department. Doesn't really apply to Administration of Regulatory Affairs, and Bureau doesn't really describe kind of the attitude that we try to take at park. We have substituted here commercial pet service facility replaces the term dog kennel. The most comprehensive of the changes apply to what was the dog kennel and kennel license, which we have removed and substituted for the new commercial pet service facility. The kennel license used to apply to any place, I'm paraphrasing, any place or lot or enclosure on which 4 or more dogs are kept, doesn't mention cats, 4 or more dogs are kept for any purpose whatsoever. And then there are a number of different regulations that flowed out of that that were similarly kind of arbitrary in nature. Go ahead. So this is the new definition. Very much the same, but broader. We had anecdotal, although the legislative intent when council passed the kennel license provisions previously, the legislative intent was to capture any activity or any location on which 4 or more dogs were present. We know from a couple of anecdotes that people thought on the room or on the kennel. So that phrase, that term was I don't know if it was unintentionally, but it was definitely too narrow. So we broadened it to the commercial pet service facility. You all can read this, I'm not going to dictate it to you, but essentially, are you involved in providing commercial service to customers for their pets? Be it daycare, boarding, grooming, mobile grooming, something else that we haven't thought of yet, some innovation that may occur in the future. Someone is entrusting and paying you to take care of their pet. Training. Lisa. Okay. The term breeder it was too ambiguous, we had commercial. So now, and I'll say that this is probably the topic that we've received the most feedback about over the last week. And we'll have more to say about this, but the term breeder was too ambiguous, so we added a definition for non-commercial breeder, and you can see what that is. We added a section, a definition for extreme weather conditions and where that comes into play. Yes, ma'am.
What are you going to do about hobby breeders? Hobby
So-
breeders are not commercial breeders.
Got it, and this is what I'd like to do. What I'm going to do my best to do, and same rules apply. Alex has got me on a clock. So I'm going to do my best to get through this in 20 minutes, Alex? 20 minutes, and then we're going to leave the rest of the time that we have until 8:30 for Q&A. But we've already received some really good feedback on that topic just this evening. So, but we'll talk about that. Okay. Extreme weather conditions. There's a provision. We added this definition because the Chapter 6 goes on to say that you cannot impound an animal of your own volition that might be on your property during extreme weather conditions. So that means that you can't trap a dog, a cat, a raccoon, a possum. No one can when it's 105 degrees out or there's a hurricane in the car, right? Because you just can't. That's not humane. Go ahead. Milch goats. There was a section that defined milch goats and then provided for a milch goat permit. That permit has not been applied for in, I don't know if it's quite 10 years, but we haven't seen one in quite some time, so we recommend that it be removed. 6-17, all dogs that were quarantined right now are technically required to be tattooed. Well, that's obsolete. We've substituted the requirement that they be microchipped. 626 and 626 and 622 really kind of play together, but what we've done in several different sections of the code is we've inserted what we hope clarifies language about ownership. What we're really the problem that we're trying to solve with this language is really relates to animal control, and it relates to complaints that we get from neighborhoods where someone lives on Main Street, 126 Main Street. They call us. It's the third time they've called us, and they say the person down at 123 Main Street keeps letting their dog out. When they get home, they just open the front gate and it runs around, or they're the owners and they don't do anything to keep the animal on their property. Right now, we don't have an effective way to say, because when we go down to 123 Main Street and we say, look, we've received complaints from your neighbor at 126 and 128 and 133 about your dog running at large, then they say, oh, it's just a stray, it's not my dog, I just feed it. Well, it's good that you're feeding it, but if you're gonna take those steps, we need you to go all the way. Or otherwise, we need you to go, there's some other avenues, some other ways that you can work with us or work with some of the rescue partners, that type of thing. It's just not okay to cause a congregation which imposes a burden on neighbors in the area without being fully accountable for it. So it's just a way to kind of cement the accountability. Okay. 631 and a couple of other sections, really if you see us mention the term enclosure, excuse me, as it applies to livestock and a couple of other things, you'll see that we reference the building code. That's really us just saying, look, if you're keeping livestock or horses or something like that, you need to go reference the building code to make sure that there's not requirements in whatever the most recent version of the building code is that might impact rules or regulations for that. There may not be, but there may be. So it's really just us saying, look, please go reference the building code to make sure that they are up to speed. 6-57, this is similar to a milch goat. This was a permit that was provided for back in 1997. Essentially, there were animals that were grandfathered. If you had a wild animal in the city limits at 1997, you were permitted to keep owning that animal for all those animals have died off. This permit hasn't been applied for in quite some time, so we're recommending that it be there. 6-90 provided, allowed us to deputize for all intents and purposes veterinarians to act as licensing authorities for us. We brought our licensing operation in-house, so we're good. We're not going to ask the veterinarians to provide that option. 101D and E, I think probably the two revisions that will have the most impact in the neighborhoods in terms of public health and safety are the addition of 2 new designations. We had the dangerous dog designation, which is provided for in state law. We didn't have, between that dangerous dog designation and dog roaming at large that we have a number of complaints for, but it's not roaming at large when our ACO shows up. We can't really, our hands are kind of tied. We can talk to the owner and try to convince them to be responsible and that type of thing, but there's not much our ACOs can do, despite how many animal control officers, there's not much our guys can do unless there's a violation occurring at the time that they show up on the scene. So we're recommending 2 new things: an aggressive dog designation and a public nuisance designation, both of which will be determined. We make a recommendation to an independent hearing officer that works in the municipal courts department. We essentially provide them with the evidence that we have, any corroborating evidence from neighbors or from the Houston Police Department. The hearing officer makes the ultimate determination. But they're not about, there's no euthanasia option for this type of thing. What it is essentially for the aggressive dog, if you've got a dog that has, and we receive reports about, has bitten someone on 2 prior occasions on your property, has attacked another animal on your property, has impinged on the ability of someone else to use the right-of-way because of behavior on your property, or is otherwise menacing or aggressive or dangerous, well, not dangerous, then this can trigger the aggressive dog determination. And essentially what you see here, that was a lot of background to say that 101D and E provide for higher penalties if subsequent to the determination of an aggressive or public nuisance dog. If that animal is found running at large, there's higher penalties for that as opposed to a simple class. You can see the 6-120, and we'll talk about this. Non-commercial breeding is prohibited. Section 6-122, the section was added. This is where we get into the commercial pet service facility requirements. And this section, much of the permitting, while the licensing requirements are translated or transposed from other sections of our code of ordinances. We regulate a lot of different things in my department and in the city. And this is just basic information. Please tell us who you are, where you operate. We're going to go ahead and let you know in this section that a license isn't transferable. It's unique to you, the operator, at the location. If you move, we'd ask you to please let us know that you moved, or if there's been a change in control, please let us know that.
I have one quick question. Let me get back up to it. Non-commercial breeding, what is that?
Non-commercial breeding?
Yeah, I
We
mean,
want to cover this.
Yeah.
We can address it. We'll definitely just take that question.
okay.
It's essentially non-commercial. So you're breeding for different, as the draft reads now. Yeah, it's in non-commercial.
Page 3.
It's on
Page 3.
If you're looking at the PowerPoint.
Of this. Ma'am,
It's on page 3 of the presentation.
ma'am. Oh,
So for personal purposes, whatever, non-commercial purposes, you're not breeding to sell them. And we'll get into that. I'll go ahead and cover kind of proactively, I think, some of the feedback that we received, the idea that we received just at the beginning of this meeting. I'll go ahead and share that with you guys and tell you about kind of new ideas that we've brought to this. So 6-123, we're removing the requirement that there be an inspection as a prerequisite to issuance of a license. What we're trying to do is move what was a requirement, a regulatory scheme that relied on arbitrary standards, that there was not really a rational, we could not find a rational basis for the existence of the prior regulations. I'm talking specifically about submitting people to the regulatory requirement only on the basis of whether or not there were 4 or more dogs, irrespective of how many cats there might be. And then if you had 4 or more dogs, the arbitrary requirement that you be located at least 100 feet away from the nearest point of human habitation, church, school, hospital, restaurant, this type of thing. We have a number of organizations that are operating today and doing so responsibly that are in technical violation of those arbitrary requirements. We could not find a rational basis to justify those arbitrary requirements. So what we've done is try to move from the imprecise language that was too restrictive, that didn't really give everyone that the language was applying to a solid idea that applied to them, i.e. the use of the phrase kennel as opposed to the broader commercial pet service facility. And then get rid of those arbitrary requirements and replace those with standards that really go at the root cause of problems that may arise from the operation of those facilities. So that's to say what we're trying to do is make it easy as possible for the good operators to operate. We want to get out of your way, just allow you to do business, while preserving the ability of us to respond to complaints and be able to take action on those folks. And we've had to do this, not many times, but unfortunately we've had to do this a few times, for those people that aren't operating. Or responsibly, I don't think anybody in the industry wants to, those people that kind of can give everybody a bottom. This is pretty straightforward. I talked a little bit about it before. And again, the regulatory structure is very similar and consistent with what you see with other regulatory requirements elsewhere in the code board. We have suspension and revocation proceedings for the commercial pet service facility license. And we also have due process protections that kind of govern and provide for an appeal of those revocation and suspension proceedings. Again, this is very consistent with what we use elsewhere in the code. My department regulates a number of different things. This is a tool that we found has been very effective in those rare instances where we need to take action against somebody because they're not operating as we would want them to. The suspension allows us to put them on notice, and it requires us to take certain definite steps, like we're required to give folks written notice that we're recommending that their license be suspended and why, and it gives them notice of the hearing, when the hearing is going to occur, provides them with information that they can absolutely have legal counsel there, that they can provide, they can call witnesses if they want, those types of things. So what we've done in 6126 is establish the grounds for suspension or revocation. What you see here on this first page are kind of what I refer to them as kind of non-negotiables, and I think the folks that are in business you would agree that these are non-negotiables for yourself as well, and they're really basic. You must provide basic humane care, adequate food, water, and shelter. You may not, you shall not treat an animal in your care cruelly. And you may not allow unsanitary conditions to persist such that you could create the condition where disease transmission could cause a risk to the animals that are in the Then 4 goes to kind of the nuisance aspect, and everybody I think understands that noise is probably the greatest risk, I think, to operations and then neighbors. And we've established a provision, and then I think this is a pretty high bar to, in order to reach this threshold, you have really refused to behave well, because it is difficult to achieve. Essentially what you must do to have your license suspended or revoked under this bullet point right here is that BARC must receive a complaint about barking animals or loud animals. We must respond to your location. We must agree that there's an unreasonably loud animal that's being allowed to persist on that property. We must issue a citation. That citation, you have to have a court date for that citation. You can have a jury trial or a trial by judge. That trial has to result in a finding of guilty. So all of that has to occur 3 times in a 12-month period before you can fall, before the ground for suspension or revocation would apply.
But when issued a citation, you have 30 days to make it right.
Yeah, that's right.
And if that happens, then nothing happens.
That's right, and that's why I'm saying this is a really, if a person were to cross this bar, they're just a bad actor. On a number of, that is a difficult threshold to reach.
You'd almost have to try to do it.
Can we hold the questions till the end?
Yes, thank you, Ms. Brown. So suspension obviously is different from a revocation. If a suspension is allowed, then the person, the operator of the business, can give Park notice that they've cured the grounds that led to the suspension, and then we're required within 72 hours, right? Within 72 hours, we're required to go to the property, review it, and then reinstate the license, okay? Okay, go ahead. Revoking, so this is, I've covered a lot of this again, a lot of this before. It's very similar to the suspension process. This is covering what the hearing officer must do. Again, this is, you'll see if you flip through chapter 46 of the code, if you flip through chapter 30 of the code, chapter 5, I'm probably missing some 7 or 22, 3. There are a number of different hearing processes. So this is, we tried to articulate that this is a well-defined process, and the city has thresholds that we have to meet in terms of notice and written findings and those type of things. So everyone has a clear understanding about when something is happening, why something is happening, and if an adverse decision is reached from the perspective of the operator, why that decision, and then what can be done about it. Good. 100-foot rule, I've already addressed this. This is one of those arbitrary conditions that we're looking at. We're recommending right now under 6-137 that on every first impoundment by an animal control officer, that animal be sterilized. Obviously, there's too many animals on the streets of Houston, and we're trying to do some